ACC and NCR and our sponsor, Kroll, are pleased to present this live and online education program, Navigating DEI Directives, Legal Obligations, and Best Practices in a Changing Landscape. My name is Cindy Boyle. I'm General Counsel of Employment at Willis Towers Watson and a committee member with the ACC NCR DEI Programming Committee. I will serve as the chapter's host for this session. Please note that the session will last 60 minutes and is being recorded. Everyone should have received a copy of today's slides in the reminder email sent to you yesterday afternoon and this morning. If you didn't receive the emails, please check your spam or junk folder. And for those of you online, we will place a copy of the slides in the chat box where you can download the slides directly. If you still need a copy, feel free to email Janine Nguyen. All remarks made by today's panelists are their own opinions and do not constitute legal advice or necessarily reflect the viewpoints of their company or firm or of ACC NCR. The next set of instructions are just for our online participants. If you've dialed into today's program by telephone, please note that you will not receive CLE credit. To be in compliance with the Virginia MCLE rules, you must be logged into Zoom with your name and company. If you have any trouble with sound, please feel free to turn on the captions for a running transcript. You can look for the tool to select captions at the bottom of your screen. You can queue up a question for us at any time during today's presentation by using the chat box at the bottom of your screen. The panel will address your questions as time permits. However, to ensure that we have sufficient time for the CLE content, we may need to hold questions. And now it's my pleasure to introduce today's panel. Rebecca Springer is a partner at Kroll's Washington, D.C. office. Rebecca has extensive experience conducting audits of personnel practices as well as providing advice on navigating the ever-changing landscape of diversity, equity, and inclusion practices. Rebecca also works collaboratively with in-house counsel, human resources teams, and labor economists to analyze compensation, promotions, and other personnel practices to assess disparities and provide strategic advice on proactive measures to address discrepancies and mitigate risk. Rebecca also has significant experience conducting discrimination and harassment investigation and counsels and conducts training on the panoply of federal and state employment laws. Katie Erno is counsel in Kroll's Labor and Employment Group. Katie represents private employers, including government contractors, with a focus on employment litigation, counseling, and investigations. She has significant experience litigating a variety of wage and hour claims, class actions, and discrimination and harassment claims. On the counseling side, Katie routinely investigates and advises clients on pre-litigation employment-related issues and compliance on federal and state employment laws. She has been actively advising clients on their diversity, equity, and inclusion efforts in this shifting legal landscape. Lauren Epps is Deputy General Counsel at Common App. She's responsible for drafting, reviewing, and negotiating complex, critical commercial transactions, advising on labor and employment, compliance, governance, and enterprise risk management. Lauren is a visionary and strategic operations leader and is recognized as a trusted advisor and innovative problem solver with a reputation for aligning legal strategy with business goals, driving cross-functional collaboration, and optimizing operations. Lauren is adept at navigating high-stakes regulatory environments and managing diverse portfolios at scale. Lauren seeks to foster stronger relationships across all organizational levels to deliver transformative business outcomes. And with that, let's get started. I'll hand it over to Kroll.
Thanks very much. And I think Katie is going to start by sharing our slides for everybody. Great, thank you. You want to advance? So first, let's talk briefly about what we're going to talk about. We want to dig in a little more deeply into the executive orders related to DE&I that have come out in the past few months. Professor Yoshino talked a bit about those, but dig in on what those really mean, the impact of those. Both the one on DE&I and then on defending women from gender ideology extremism, and talk a little bit about the litigation that is ongoing with respect to those EOs. We're going to talk about the conflicts that we see between what's happening in the federal government and what the state laws require on diversity, equity, and inclusion. And then most importantly, we're going to have a conversation with Lauren Epps to talk about really sort of best practices. How do we address these issues from a really practical perspective that each of you can think about for your own companies and how to address these? So moving on, first we'll talk a little bit about Executive Order 14173, which came out the day after the inauguration and really made sweeping changes to the federal government's approach to diversity, equity, and inclusion, and particularly affirmative action. So the first thing that the executive order did was revoke Executive Order 11246, which was a Johnson era EO that had been in existence for 60 plus years, and really established the whole scheme as to what government contractors needed to do with respect to affirmative action related to race, gender, religion, national origin. But with the president's executive order, essentially wiped out the obligations to engage in affirmative action for women and minorities, really eliminated a vast majority of the work done by the Office of Federal Contract Compliance Programs, the OFCCP. So it is a sea change for government contractors with respect to what their affirmative action obligations are now. It's really important to note that the key affirmative action obligations for federal contractors have always been women and minorities under Executive Order 11246, and then veterans and individuals with disabilities under VEVRA and under Section 503 of the Rehabilitation Act. Those two statutes, VEVRA and Section 503, those still remain. And so all government contractors and subcontractors still have an obligation to engage in affirmative action for veterans and individuals with disabilities. You still have an obligation to perform to develop annual affirmative action plans, could still potentially be audited by the OFCCP for those obligations. The OFCCP is in a bit of flux at the moment. There's some suggestion that it's going to be substantially reduced, cut by 90% of its workforce, potentially just remain to enforce VEVRA and Section 503. But there are some thoughts that it could also potentially be used to try to advance the administration's agenda with respect to its position on DE&I more broadly. So we'll just have to see what may be coming down the road. I want to talk a little bit, if you can go to the next slide, Katie, about another piece of the executive order and really the significant impact on government contractors, because what it says is that in every contract or grant going forward will include a certification that contractors or grantees are required to make that include two components. First, you have to agree that compliance with all of the federal anti-discrimination laws is material to the government's payment decisions for the purposes of the False Claims Act. And then second, you are certifying, again, subject to this False Claims Act liability, that you as a contractor or grantee don't operate any programs promoting DE&I that violate any applicable federal anti-discrimination laws. Now, the executive order does not define what programs promoting DEI could violate applicable federal anti-discrimination laws, So it leaves contractors largely to question what that might be, and we'll talk a fair amount in a minute about sort of how to understand or best, try to guess what the administration's view is with respect to what sort of programs violate the federal anti-discrimination laws. On the next slide, this is an example of the certification language. It's important to know that there is no uniform certification language yet approved by the FAR Council. It is up to each agency to issue their own certifications. This is an example of one that was going around in the early days that a number of agencies started using. But we have seen all types of certifications as agencies come up with their own language. We're also seeing that some contractors are taking it upon themselves to flow down some sort of certification to their subcontractors. There is nothing in the executive order that says there is a requirement for contractors to flow down this certification as yet. But we have seen some contractors taking it upon themselves to do that and throwing in all sorts of other pieces that aren't in this executive order, other executive orders, for instance, within those certifications. So I say all that just to say, if you are a government contractor, if you're receiving these certifications, make sure you read them very closely because they are not uniform and may be asking you to certify to different things depending on who it is coming from. Next slide, Katie. The other thing that we've seen in addition to the certification requests coming out was a GSA class deviation that was issued to remove the purpose of it for the most part was to remove a number of the FAR clauses related to affirmative action. So eliminating those clauses that no longer are operable because President Trump revoked 11246. But interestingly, at the end of that GSA class deviation, it also included a requirement that as of February 15th, when it came out, all uses of the term gender identity are not to be recognized or used by federal contractors. This was really startling language when it came out. First of all, the administration has taken the position instead of gender identity, it is called gender ideology. But this idea that federal contractors cannot use this language is certainly concerning because, as we know, many state laws actually require the protection, the anti-discrimination based on gender identity. I think the one thing that is really beneficial, however, from this language is you'll see the rest of it where it talks about it doesn't affect existing U.S. laws on civil rights or any laws that generally apply to a company, regardless of it's a government contractor. So I think that government contractors can take some solace, some defense in this additional language to say, look, we are required, for instance, to say we don't discriminate on the basis of gender identity under certain state laws, and so are going to continue to use that term in that context, but recognize that this is the position of the federal government with respect to the term, the gender identity being used. Next slide. So I want to talk a little bit about this certification requirement because the False Claims Act piece of it is really a key component. Excuse me, a key component of the certification itself, because you are now, if you certify to this, saying that you are subject to the False Claims Act if the government were to say that in fact you are engaging in any activity that violates the federal anti-discrimination laws. So no, not just are you potentially subject to a discrimination claim if there was such an allegation or finding, but here again, also a False Claims Act claim. False Claims Act includes substantial damages, up to triple damages, and damages based on invoices to the government. So depending on the amount of your contract, that can be substantial. It also opens the door for a lot of potential FCA whistleblower claims. What we expect that we're going to see is that if an employee is unhappy, is disgruntled, thinks that a diversity training, for instance, was inappropriate or was denied a promotion, for instance, and believes that it was because they are not a minority or a woman, etc., then not only could they bring a discrimination claim, but can now also bring a potential False Claims Act whistleblower claim. And so then you have all of the protections involved for a whistleblower and that potential liability as well as a discrimination claim. The one last thing I'll say about the certification requirement is that we've gotten a number of questions about whether sort of the extraterritorial application of this certification requirement, because what we saw is a number of embassies, for instance, sent these certification demands to foreign entities. It's not a simple question as to whether it applies or not. Title VII, for instance, does have some extraterritorial application if you have U.S. citizens working in your foreign entity, then they are covered by Title VII. If you are a U.S. company operating overseas, Title VII may apply. Or if the entity is controlled by a U.S. company, then Title VII and the other federal anti-discrimination laws may apply. So to the extent that you have international operations and you may be getting some of these certification requirements, you really need to do that analysis to determine whether it actually applies in your situation. Moving on from the certification requirement that was specific for federal contractors and potentially subcontractors. We'll see how that plays out. The executive order also reaches further to the entire private employment sector, because what it does is requires the Attorney General and the heads of each agency to create this enforcement plan to go after what they consider to be the most egregious and discriminatory DEI practitioners. And you'll see here in that third bullet who they are potentially targeting. It is up to 9 within each sector, so that can be many multiples of 9. We don't know yet what this list is going to look like, but it is said the idea is essentially that the Attorney General and the heads of each agency will come up with, for all intents and purposes, a hit list of those that they believe are the most egregious DEI practitioners for potential investigation and enforcement actions. And they have even suggested that it could be criminal as well as civil investigations and enforcement actions in this arena. So we expect that there will be a list coming out next month at some point, and we'll see what comes out of that. We've already obviously seen the administration engage in a number of investigation and enforcement actions, for instance, with respect to higher education, and we expect to see more of the same as they develop this plan. So moving on, as I mentioned, there's no definition in the executive order of what DEI actually violates applicable federal anti-discrimination laws. There is the administration's position, which we can try to cull from guidance from agencies, from statutes. But I think as Professor Yoshino was talking about, really the cornerstone of all of this is the case law that we have on anti-discrimination laws and the applicability, how those are interpreted. But there is a distinction here, I think, between what, as Professor Yoshino was talking about, what may be defensible should you have to go through the entire legal process and get to the Supreme Court, versus what may face the ire of the administration, what may make you a target. And what we are seeing from most companies is they really are focused on not just necessarily where is the absolute legal line, but what can we do that will reduce our risk of being a target in this area, while still remaining committed to the values of diversity, equity, and inclusion. So some of the things that we have seen that give us some guideposts as to what may be considered unlawful. First, there was this OPM memo, which was directed at agencies, but gives us some sense of what the current administration believes to be unlawful. Things like diverse hiring slates, so pools of applicants, not necessarily having a requirement that a selection be a diverse candidate, but rather that you have a certain percent of diversity in your applicant pool, that may now be considered unlawful. There's been a lot of discussion about whether you can still have employee resource groups or affinity groups. The answer for the moment seems to be yes, as long as they are open to all and that they are not limited to certain groups. So for instance, if you have a women's affinity group, if someone wants to create a men's affinity group, you can't prohibit that. And that they're really focused more on social cultural events and not so much on providing any sort of benefit that is limited to the members of the group. Next slide, Katie. We also got some guidance from the EEOC in March about what they view to be discriminatory. Certainly, anything that provides a benefit based on a particular protected characteristic or excludes anyone based on a particular characteristic is going to be discriminatory. That's actually always been the case. But they have expanded this to include things like mentoring, sponsorship, networking. Again, there's discussion of the diverse slates or requiring a diverse panel for interviews. And then they make a comment about pre-employment questions about race can suggest that race is being used as a basis and could potentially be evidence of discrimination. This is a significant issue for government contractors, for instance, who have always collected race and gender information about applicants. They were previously required to, now no longer, given the that 11246 was revoked, but a question about whether you continue to collect applicant data, which may be very useful for your non-discrimination obligations, but nonetheless could potentially be viewed as an issue by the administration. Moving on to the next slide, you've also seen that there were a number of EOs targeting law firms and EEOC letters that went out to 20 law firms. I'm not going to go into the details of these in the interest of time, but again, these also provide some insights into what the administration believes is unlawful or has taken DEI too far. We also have the Dear Colleague letter from the Department of Education laying out what DEI type programs they believe to be unlawful. Worth noting that letter was just enjoined yesterday in a lawsuit, a court decision, because several organizations brought suit against this Dear Colleague letter. So this is a constantly evolving area of the law as we see new executive orders come out, new lawsuits filed, we see injunctions being issued, and then those injunctions being stayed. It is day to day trying to even keep up with what the legal landscape is can be challenging. For the next few slides, I think we're not going to discuss them. They are in your materials so that you have them as resources. This identifies some of the key anti-discrimination statutes, some of the key appellate and Supreme Court cases that are ongoing or that have that really color the understanding of affirmative action and DE&I in the current environment. We have the Ames case, which the Supreme Court is going to hear before the end of this session, which will really give us, I think, the most relevant picture as to how they are interpreting anti-discrimination obligations. And then we have a number of, as I said, a number of litigations that have been filed specifically with respect to the executive orders. This one was filed in Maryland, specifically against the DEI executive order. It enjoined the certification, so agencies were prohibited from sending them for some period of time. However, the Fourth Circuit overturned that, so now agencies are again sending out the certifications. There's also one on the next page. These are some other challenges. The Chicago Women in Trades one at the bottom. There is actually, as a result of that, a preliminary injunction that prohibits the Department of Labor from sending out certifications. So if anyone gets certification requests from the Department of Labor, know that those are subject to this Chicago Women in Trades injunction. That was a very fast sort of run through the executive order. I'll turn it over to Katie now to talk about one of the other key executive orders.
Right. Thanks so much, Rebecca. So moving on, I'm going to speak for a few minutes about another executive order that impacts private employers, defending women from gender ideology extremism and restoring biological truth to the federal government. This is another one of the first executive orders to come out. It starts by stating up front that it's the policy of the United States to recognize two sexes, male and female. It goes on to say that they are not changeable, and that under the president's direction, the executive branch will enforce all sex protective laws to promote this reality. And then the following definitions shall govern all executive interpretation and application of federal law and administration policy. And then it goes on to say that sex shall refer to an individual's immutable biological classification as either male or female, and that sex is not a synonym for and does not include the concept of gender identity. The executive order goes on to list several directives kind of with this new definition in mind. It directs federal agencies to issue guidance to support its view. It expressly disagrees with the prior administration's view of the Supreme Court case in Bostock, that case requires gender identity-based access to single-sex spaces, and we'll get into that a bit in a few minutes here. Prohibits federal funds to promote gender ideology, directs the Attorney General to issue guidance to ensure the freedom to express the binary nature of sex and the right to single-sex spaces in the workplaces, directs the Attorney General, the Secretary of Labor, and the EEOC, as well as agency heads, to prioritize investigations and litigation, to enforce the rights and freedoms identified in the executive order. And then finally, it directs the Assistant of the President for Legislative Affairs to present the President with a proposed bill with text that would codify in law the definitions that appear in the executive order. So stepping back for a minute, how does this impact private employers and their DEI policies and practices? Well, we all know that Title VII protects discrimination, among other things, discrimination in employment on the basis of sex. So what this executive order is saying is that it's the administration's view that gender identity is not incorporated into the definition of sex, and therefore under federal law, gender identity is not a protected characteristic. It doesn't just kind of limit the view of what is covered by Title VII, but it actually goes a step further too, and appears to be saying that the federal anti-discrimination law encompasses the right to use single-sex spaces at work. So, for example, it would be discriminatory to require a cisgender woman, so meaning a woman whose gender identity aligns with the sex that she was assigned at birth, female, to share a single-sex bathroom space with a transgender woman. And so, what we are kind of there's two main questions that we've been seeing from employers. The first is the question of how to handle the single-sex spaces like bathrooms, particularly where they have policies in place that permit employees to use the bathroom that corresponds with their gender identity. And the second is whether for employers that have policies that permit their employees to identify preferred pronouns. For example, many employers in their email signature will have an option to identify preferred pronouns should they make any changes to that policy. So let's get into a little bit more about the guidance that we have to answer those two questions. So first, following the executive order, the EEOC, which we know is the agency tasked with enforcing employment anti-discrimination laws at the federal level, came out with this response. So the acting chair, Andrea Lucas, announced that one of her priorities for compliance investigations and litigation is to defend the biological and binary reality of sex and related rights, and again, including women's right to use single-sex spaces at work. The agency removed its pronoun app, which allowed employees to display their preferred pronouns. It ended the use of the X gender marker during the intake process when an employee files a charge of discrimination. And also removed materials promoting gender identity on the Commission's internal and external websites. So, going back to those two questions, the first, the issue of pronouns, is a little bit easier. There is nothing unlawful under the administration's read of Title VII with permitting employees to use their preferred pronouns, or including them in signatures. While the administration and the federal government, you may have seen, took the position that federal employees should remove pronouns from their email signatures. There's nothing unlawful, right? So it's just that the administration doesn't view Title VII as expanding protections based on gender identity. The question of single-sex spaces, including bathrooms, is a bit trickier. Move on to the next slide. Is a bit trickier because it's not saying simply that Title VII does not require employers to permit employees to use the same sex spaces associated with their gender identity, but that by doing so, they're actually violating the Title VII rights of other employees. So, kind of stepping back, let's look at the case law and what the cases say. So we have this Supreme Court decision in Bostock, from 2020, that there the Supreme Court held that on the basis of sex, discrimination on the basis of sex under Title VII necessarily encompasses discrimination based on sexual orientation and gender identity. So the rationale that the court gave is that an employer who fires an individual for being homosexual or transgender fires that person for traits or actions that it would not have questioned in members of a different sex. So therefore, sex necessarily plays a role in the adverse employment decision, which is exactly what Title VII prohibits. That said, the opinion explicitly did not opine on the use of single-sex bathrooms. It said, it's written in there in the opinion under Title VII, we do not purport to address bathrooms, locker rooms, or anything of the kind. So we have there's certainly conflict between the Supreme Court's definition of sex to encompass Title VII, with respect to that aspect of the order, but an open question from the Supreme Court, at least when it comes to single-sex spaces in the workplace. There's really not a lot of case law on this. At the appellate level, we have a decision from over 20 years ago out of the Eighth Circuit that held that a school's policy of allowing a transgender woman to use the faculty restroom, the women's faculty restroom, did not create a hostile work environment under Title VII for other employees. So that, that goes kind of is in some tension with the position the EEOC and the administration is taking. But again, it's one decision from a long time ago. Then we have a more recent district court opinion from 2016. I guess that's not that recent, 9 years ago, but from the District of Nevada. And there, the court granted partial summary judgment to a transgender police officer whose allegations included that the school district banned him from using either the women's or the men's restroom. And among other reasons, the court held that the employer's refusal to allow him to use the restroom associated with his gender identity violated Title VII because the employer treated the officer differently than both male and female employees. So kind of as it stands now, where we are, we have the text of Title VII at the moment is silent on whether sex encompasses gender identity. The administration, the executive order says it does not. Bostock says it does, but it doesn't opine on what that means for single-sex spaces. We have some lower courts that suggest that Title VII requires access to single-sex spaces based on gender identity, still not fully developed. We know that the EEOC takes a different view and is going to be prioritizing investigations and compliance consistent with the executive order. So what we're likely to see in the near term is both an attempt to revise the language in Title VII, which of course will have to go through the legislative process, and then likely kind of in the meantime to see more litigation on this. And then one moment before we go on to state challenges is just to say that there has been a legal challenge to the executive order. It was stemming from a case that was filed last year seeking declaratory judgment and relief regarding a New Hampshire law that bars transgender girls from participating in school sports. And then after the executive order, the plaintiffs amended their complaint to include seeking declaratory and injunctive relief. And we're still waiting a response from the federal defendants. Moving on to conflicts with state law. And as Rebecca touched on earlier, to kind of add to the complexity of the question of single-sex spaces, there's a potential for a direct conflict between the administration's interpretation of Title VII and state law protections regarding transgender status and gender identity. So we have more than a dozen states that include gender identity and expression as a protected status under state law. These include protections against discrimination based on gender identity or expression in employment and or public accommodations. And in certain states, it's actually illegal to prevent an employee from using the bathroom associated with their gender identity. So for example, I've included here for reference, although we don't have time to get into the nuances, the current regulations in California and New York. So again, potential for really a direct conflict there, lots of nuances, important to be mindful of this, to monitor the state laws where you operate and work with for in-house counsel to work with outside counsel as may be necessary in your internal clients if this question comes up. And then kind of moving away from that issue and back to the first executive order that Rebecca was discussing, as we know, that eliminated the federal affirmative action obligations for women and minorities and suggested that it's unlawful to set representation goals. Where that potential conflict comes with state law is that there are some states that have their own affirmative action requirements or obligations for state contractors. So certain employers who are state contractors may be expressly required to take affirmative action when it comes to women and minorities and set goals. So this poses a potential direct conflict for employers who have contracts with the state and also have these obligations. So something else for employers to be mindful of in this space. And then just one more word before we transition. Currently, the federal government still has federal requirements for set-asides for minority and women business enterprises in the subcontracting space. Those are still on the books. We say here uncertain future because we aren't sure exactly what the administration will do, but just wanted to flag that as well. And that brings us to what we hope will be a very interesting discussion with Lauren on the practical implications for employers, right? What should employers do with their DEI programs and activities against this backdrop? And as Professor Yoshino talked about at the end of his presentation, what we're seeing is many employers doing a comprehensive privileged analyses of their DEI programs and public facing statements related to diversity, equity, and inclusion, kind of against using this as an opportunity to do an audit sort of against this backdrop. So looking at things like, kind of holistically, right? So every employment decision from sourcing and recruiting and hiring to career development programs, ERGs, compensation programs, internal communications. Some are revisiting kind of title and office names and functions, external communications, and supplier diversity programs. So Lauren, without recognizing that these are in fact privileged analyses, can you share from the in-house counsel perspective, kind of at a high level, what your approach has been and if there have been any challenges you've faced as part of the process?
Yeah, I think, like you said, from a high level, our approach has been really doing that inventory and audit with regards to just comprehensive practices, procedures, internal, communications and messaging, as well as external facing, materials and communication. So we're really in the phase of, just getting our ducks in a row and taking an inventory of where we stand.
In terms of like scoping, do you have any thoughts or views on like how do you kind of balance the legal spend and where to prioritize and kind of like this is basically everything related to employment. So any thoughts on that?
Yeah, absolutely. We're definitely mindful of that. And I imagine that everybody in House Council level is mindful of, the scope. What I've been seeing and what we've been, really taking into account is to hone in on those areas that are specifically impactful to our industry, to our organization, and, set up internal agile teams, cross-functional teams that can quickly respond, that can deal with digesting, advice as we are receiving it from inside counsel, that so that we can make strategic decisions on deploying and implementing things. But absolutely, we're, keeping our arms around things. Sometimes we're sending discrete issues to council, or even contemplating engagements, on a flat fee for something that pertains to, again, a specific discrete area.
Thank you. Yeah, it is a busy time for all lawyers, in-house and outside counsel. So getting into a bit more of the nuances of those various areas, starting with recruiting and hiring. One of the things that we heard from Professor Yoshino, and has been consistent with kind of how we've been approaching it, is that there is a spectrum of risk for diversity, equity, and inclusion activities. And specifically when it comes to recruiting and hiring, we've seen employers kind of not make changes to hiring practices that are intended to cast a wider net, right? So things like recruiting from HBCUs, and continuing diversity focused initiatives that are meant to be inclusive, but rather instead focusing on eliminating hard lines like diversity slate requirements, diverse interview panel requirements, and aspirational representation goals. Is there anything you can share with us, sort of at a high level, about your views on that?
Yeah, what I've seen and heard, and been a part of, is really focusing on keeping conduct, practices, policies defensible. And what we've seen is that, it's our understanding is that it's still appropriate to pursue, a broad, casting a wide net, pursuing a broad range of talent, have a broad range of activities and programs, but that they should be focused on, capturing everyone, essentially, right? To say that it's okay if we target or if we're recruiting from an HBCU, but we have similar programs, or even for vendors, right? We're looking for this kind of vendors, but we also have a program that seeks to engage, other groups. So essentially, it's focusing on, being inclusive, and really creating and cultivating a workplace and an environment that is welcoming and inclusive for all. So that's what I've seen people focusing on, and really highlighting that as being defensible. Also heard folks say that, where you're a mission-driven organization like us, or where you have an articulated business purpose, it is always defensible to be able to point your conduct, your policies, your procedures to forwarding your mission and aligning with your business purposes.
And actually, I think that's a very, oh wait, did I just skip? I skipped career development, and was gonna go right into corporate values. We'll talk about that in a second. With respect to career development, we've heard some mention of employee research groups, affinity groups. These programs, again, not being mindful to what we've seen are folks being mindful, recognizing that these really do serve an important purpose, and not eliminating them altogether. And again, not to Professor Yoshima's point earlier, kind of not being so kind of reactionary that you're eliminating programs that are really beneficial, but instead looking at looking at them holistically, emphasizing both in writing and practically that they are inclusive, right? So that they're not there are no aspects of these that are preferential or exclusionary based on a protected characteristic, but rather just kind of doing an inventory of both how they're described in writing, so that there's not like any kind of written appearance that they're discriminatory, and then ensuring that they aren't actually in practice discriminatory. Do you have kind of any thoughts about aligning those two things and how in your approach?
Yeah, I would say one thing that I've heard and has been implemented recently is making sure you're going a step further and expressly stating that, let's say, a group or an event, while it's highlighting or celebrating maybe Pride Day, but going on record is expressly stating, all employees are welcomed and encouraged to attend. Same thing with other groups where it may be, geared towards celebrating one group, but also going on record, making sure we're defensible there, that it's open to all, that all are welcome, all are encouraged, and just again aligning with that inclusivity rather than focusing on some of the other aspects that can subject you to additional scrutiny in this climate.
Yeah, that makes a lot of sense. I'm actually going to pitch this question to Rebecca, who is our in-house expert on all things pay equity, and just to talk for a moment on compensation programs, and see if you can just speak briefly to what, if anything, kind of how employers are making changes or looking at their pay equity programs kind of as part of these analyses.
Yeah, thanks. We're getting that question a lot. I will say, I think most companies are continuing their pay equity programs. There is still clearly an obligation not to discriminate on the basis of race or gender or any protected class in compensation. So it still is very important and pays big dividends to continue to ensure that you have an appropriate pay equity framework, to do privileged analyses of your compensation, to know where those vulnerabilities may be. I think one of the things that we are seeing is that companies are now looking at and potentially remediating variances that they see that are disfavoring men or Caucasians, as well as women or the minority racial groups. We didn't used to see that. That now is more and more companies are taking that approach to say we are clearly looking at this, by race and gender. It is not just about minorities and women, but any differences that negatively impact based on race and gender, we're going to dig into. Some may be aware that there was an executive order issued 2 days ago, essentially trying to eliminate the use of the disparate impact theory in discrimination cases. And we've gotten a number of questions of how that may impact pay equity in other areas. It'll be interesting to see what develops from that executive order. There are a lot of mandates to take actions by the Attorney General and the agency heads. However, we have an extensive history of case law establishing the disparate impact theory. So I would certainly not say disparate impact theory is all of a sudden dead. That is still very much a relevant theory of discrimination, and so should be taking that still into account in thinking about how you approach pay equity.
You, Rebecca, and we as is often the case, we finished our slides before the executive order came. We had to turn them in before the executive order came out. But this is a very dynamic legal landscape, so I'm glad we were able to work that piece in. And the last kind of area to talk about with respect to the audits is communication, kind of internal and external communications, and where I've seen employers where we've seen employers kind of try to balance is sort of to what you were saying earlier, Lauren, like making sure they're still emphasizing their corporate values, and those largely have not changed. Also, the fact that they comply with the law, right? I mean, the compliance with federal anti-discrimination laws has been a requirement for, as long as Title VII has been around. So making clear that they comply with the law, but really kind of looking at their statements to see what may be, kind of flagged or problematic, kind of in light of the current environment. And, one strategy that we've seen is clarifying what diversity means. So, not saying that diversity is really about a diversity of protected characteristics, but focusing on how, a diversity of experiences and backgrounds and points of view, and really emphasizing inclusivity, both as part of the kind of consistent with the corporate values that have always been. So Lauren, can you speak at all to sort of that balance between corporate values and changes that might be being made to communications, both internal and external, in this environment?
Yeah, absolutely. I think that's one of the biggest challenges or immediate challenges folks are facing is the messaging. And what I've seen that's been successful is really focusing on what the intentions have been, because right now, again, just the title DEI has a lot of meaning to it. It's, again, triggering a lot of scrutiny. And so if we can, state what our goal has been, which is to provide an environment that is welcoming, that promotes the success of all of our, employees. If our values can be espoused in ways that don't use those buzzwords that carry a lot of legal uncertainty and potentially significance with it. That's what, we've been focusing on. And that's what I would suggest, as highlighting. I also think, to your point, just promoting a culture of compliance and recognizing that things will change, the landscape will change, and maybe building in some of that agility into how we are talking about our products and our services and our organizations, and how we are highlighting our programs. Having that flexibility is important to quickly adapt and reframe where necessary.
Yeah, that's helpful. And I think, when we were chatting yesterday, you said something to the effect of how, like, even though these audits are stemming from the executive orders, it really is good practice to be doing audits, right? As in regularly of your policies and practices, to ensure that they're aligned.
Yeah, absolutely. I think it's a very good practice for in-house counsel, right? Nobody should be more intimately aware of your business and how to speak to your business and what your organization does or does not do. We should be very capable and competent and equipped with all of the information. So in order to do that, we should regularly be auditing, our activities and our protocols and our IP, our assets. We should be regularly, assessing and evaluating if there are changes that need to be made. Oftentimes there are, just based on other things that are completely unrelated to the executive orders and DEI work. But yes, I think this just brings that front and center for us.
So we have just a few minutes left, and I want to also give you an opportunity, Lauren, to close with your sort of kind of high level practical tips that we haven't been able to cover. This is just briefly a slide in here that will, for folks to reference. I just want to say a minute about supplier diversity programs, which have been subject to challenge. The legal theory being that they violate Section 1981, which prohibits considering race in contracting. Again, the American Airlines decision that was filed, or sorry, case, not decision, there has not been a decision, was filed in February and really lays out the legal challenges to supplier diversity. So check that out when you can for those of you that have supplier diversity programs. And I will hand it back to you, Lauren, just to give any closing practical tips that you would like to cover before we end our session.
Yeah, I think we've covered most of them. We're going to document our process, make sure we're showing, how we are compliant and promoting that culture, focus on inclusivity, rather than other things that could subject us to additional scrutiny and perhaps liability. We just talked about auditing our assets, and then obviously making sure that we're staying apprised of the landscape and engaging counsel on your fact-specific issues that impact your industry.
Thank you. And then just to close, we're giving this all to you as a kind of a reference point of how we at Kroll have been thinking about this, the sort of the risk spectrum of activities that fall into kind of like the four risk zones of low risk, moderate risk, higher risk, and highest risk. So you all can take that with you to look at, and just know that that's how we've been thinking about those things. And with that, I will hand it back to Cindy. And thank you all so much for joining us today.
Great, thank you so much. It was just a great practical program. We really appreciate it. And on behalf of the chapter, we just want to extend a special thanks to our sponsor, Kroll, and to Rebecca, Katie, and Lauren, our panelists.
Good morning. ACC NCR and our sponsor, Hunton, are pleased to present this live online education program, Managing New Risk and Opportunities in the AI Workplace. My name is Ariel Martin, Assistant General Counsel of Compliance and Contracts at Common App, and a committee member of the ACC NCR DEI Programming Committee. I will serve as the chapter's host for this session. Please note that this session will last 60 minutes and is being recorded. Everyone should have received a copy of today's slides in the reminder email sent to you yesterday afternoon and this morning. If you did not receive the emails, please check your spam or junk folder. For those of you online, we will place a copy of the slides in the chat box where you can download the slides directly. If you still need a copy, feel free to email Janine Nguyen. All remarks made by today's panelists are their own opinion and do not constitute legal advice or necessarily reflect the viewpoints of their company or firm or of ACC NCR. The next instructions are just for our online panelists. If you have dialed in today's program by telephone, please note that you will not receive CLE credits. To be in compliance with Virginia CLE rules, you must be logged into Zoom with your name and company. If you have any trouble with sound, please feel free to turn on the captions for a running transcript. Look for the tool to select captions at the bottom of your screen. You can queue up a question for us at any time during today's presentation by using the chat box at the bottom of your screen. The panel will address your questions as time permits. However, to ensure we have sufficient time for CLE content, you may need to hold questions. And now it is my pleasure to introduce today's panelists. Robert Quackenboss is a partner at Hunton. Bob is a litigator who represents businesses in resolving complex labor, employment, and trade secret, non-compete, and related commercial disputes. He is recognized by Chambers USA as a leader in labor and employment and as a labor and employment star in benchmark litigations rankings. He also serves as co-chair of the firm's Unfair Competition and Information Protection Task Force, which concentrates on trade secret theft, restrictive covenant, and non-competition matters. Riley Moore is an associate at Hunton. Riley counsels employers on labor management relations, OSHA compliance, and complex employment law issues. Riley has worked on multiple union organizing campaigns and counseled employees through the representation petition process. Riley counsels employers on other labor management relation issues, including collective bargaining and grievance and arbitration procedures. Aisha Jorge Massengale is a former head of employment law at Sonos and Under Armour. She is an experienced attorney and human resources professional who serves as a key advisor on employee relations, labor, employment, and investigations matters. Aisha has an established track record of integrating human resources to deliver mission-critical employment-related legal advice and supporting teammates globally. Now let's get started. I'll hand it over to Hunton.
Good morning, everybody. Thank you for joining Aisha and Riley and me this morning for a very important topic. Wanted to spend just a moment showing you a bit about our Hunton Emerging Tech Group so you have an idea where today's topic fits into our emerging tech practice. We began this emerging tech practice in the year before the pandemic hit. And then, of course, with the pandemic, tech in the workplace and tech in employment skyrocketed, really creating all of the new issues that we're dealing with here in this array on the slide. And beyond the AI that we're going to be talking about today, we're dealing with, of course, BYOD program compliance, robotics, biometrics, location monitoring, and all of the things that helped employers get through the pandemic and that are creating new challenges for labor and employment and in-house counsel today, very significantly. But with today's focus on the next slide, we're going to spend the day talking about artificial intelligence in the workplace and a few introductory comments here about why it matters and why it matters to this group in the context of diversity programming and such. The prevalence of AI seems very apparent to those of us who practice in this space, but there are more people out there than I give credit for that haven't embraced the notion that this is coming on like a freight train and AI is going to change the landscape and the culture of so much in pretty much everybody's workplace and management group. A recent McKinsey study told us that 78% of companies use AI in some fashion in 2024. And a few of the other reasons why you all need to, I think, focus on AI, learn more about it and how it will impact your surroundings and workplace is that, sooner or later, automated decision-making tools are going to come to you across your desk. And it is going to be the human component, you, who will ensure that it's going to be used efficiently, productively, and in compliance with law. So you are going to be the safety net for whatever AI tool is put in front of you, and don't let anyone tell you otherwise. That's going to be really very essential. The other matter is the emphasis today on merit-based hiring, attacks on DEI programs, and so forth. What you'll hear today is that AI exists because it learns from what has historically occurred and tries to make projections, recommendations, and analysis based upon that. It studies what has happened historically, what's happened under the law, the history of information on a topic, And when you look back at hiring and employment, what is it that AI has studied up on and learned from our history? Things like inclusion, the value of diversity, programs like affirmative action, things like disparate impact concerns. Um, and now we see with increasing momentum, all of those concepts on which AI has built itself and its products are now changing in focus and intention and goals, disparate impact just as recently as yesterday. So it's very important that you, as the human overlay safety net, um, recognize that until something changes in AI, it is spitting out products and information and recommendations that is based on past learning. And you have got to be the ones to look at it through a filter, a lens of what's happening today and tomorrow, and is it still reliable? We're going to spend a lot of time talking about increasing regulation. States, municipalities, cities are regulating AI at increasing paces, and it's important for us, the human component, to know about these changes and ensure that we're complying with them. And so on the next slide, just a quick buzz through our agenda. I'm going to spend a few minutes talking about what is artificial intelligence, then a quick touch upon the popular AI tools in the workplace, a little bit deeper dive on the law regulating AI in the workplace, the risks, and then we'll spend about a third of our time talking about best practices and compliance. All right. A few comments here briefly about what artificial intelligence is for those of you who are very new to the concept. And essentially, artificial intelligence is technology where people have designed machines that will carry out work only done by humans and human brains before. They're machine-based systems that are designed to make predictions, recommendations, and become a tool for management in the workplace, create efficiency, and at an increasing rate, perhaps even replace the human component of some of these job functions. Generative artificial intelligence, or GAI, has come on strong more recently. Things like ChatGPT, Siri, Copilot by Microsoft. Many of you may be using Copilot, but this is a tool where AI actually creates content for you, eliminating a lot of the busy work that has kept management, HR, in-house counsel occupied, busy, overburdened. These tools create documents, information analyses for you that will lighten your load. And that's what GAI is about. And so the most popular workplace tools these days are chatbots. That's not at all exclusive to the workplace. These are little bubbles that pop up. You've probably seen them in other contexts like retail, but chatbots are increasingly used to interface with candidates for purposes of screening individuals as candidates, for gathering information from them, for hiring, all eliminating the human component at that first stage of communication with possible candidates for hire. Automated candidate sourcing, AI products are now actually in the business of reaching out. Some of you may have received communications from AI through email or text, finding you based upon your profile on the internet, identifying you as a candidate for the employer, and cold calling you to determine your level of interest, and then working you into the work stream for hiring and recruiting. Intelligent resume screening that 10-inch stack of resumes that employers receive when they post a job. AI products now more and more will review those, do a first level, second tier review to really whittle that down to the best candidates. And then moving on to assessing a candidate's particular skills and ability, AI now produces testing products to measure cognitive skill, analyze compatibility for a particular job. And then once employed, there's a whole array of AI products now dealing with performance management and retention. Retention meaning designing a worker's job and challenges so that they are more likely to succeed, enjoy job satisfaction, and stay. We'll spend a little bit more time talking about specific performance management tools in just a moment. And then generative AI, as I talked about previously, creating content both for applicants and for your managers, which save time, polish results. So that is the whole array of workplace tools that we're talking about. And so first in employment screening, I think the thrust of this story regarding employment screening is really the lower left corner of this slide, where employment screening tools will help us gain insights into the talent pool. That is entirely a human task in the past. Automate all of the high volume tasks that HR, recruiters, managers have to engage in regarding screening, background checks in particular. The law requires that it's not just that there be a human component. More and more AI is taking over that role as well. All of this decreases time to hire, decreases turnover theoretically because you are hiring more successfully and accurately. And then a few examples of productivity monitoring tools. When you have successfully hired an employee and they are in the system and they are working, you have tools now available such as keystroke monitoring, which monitors keyboard activity to determine productivity. What are they doing? What's their speed of work? Activity trackers, knowing about their web browsing habits, knowing about the applications they spend time on, periodic screenshots, email tracking, how much time are they spending on messaging, data loss prevention solutions, picking up anomalous patterns that suggest that people are spending time where they're not supposed to be. Perhaps that can lead to learning about theft or some other improper conduct. Facial recognition tools, really fascinating. Not only will you be aware when the person is somewhere or not somewhere, but now they generate that person's information about that person's mood. Are they enjoying what they're doing? Are they engaged? Are they interested? Or are they not? All of that is important for employee retention, as are engagement algorithms, which perform that same function largely. And then I know Aisha, this is on the next slide, this is a very important area for her from her in-house counsel perspective. Aisha, you want to share your thoughts about productivity monitoring tools?
Yeah, thanks, Bob. My brief comment is, as with anything, there's the can you do it and there's the should you do it, and what are the downside implications. For example, I think there's a trucking company out there that actually monitors the amount of rest or energy that their drivers have, because the idea is to improve safety. I would say for those of you in more corporate settings, it can engender a certain level of mistrust amongst your employee populations when they are constantly subjected to monitoring. And I think sometimes it can also be the tool of a lazy manager to really go through giving the kind of feedback, performance feedback that an employee might need. So my watch out there is just to make sure that in all of these things, while it creates better speed and efficiency, there's always pressure on the recruiters to hire faster. We just want to be mindful that, again, our managers stay involved in a lot of these processes and that they're always still anchoring to things like performance rather than defaulting automatically to the tool. Because as we'll discuss a little later, there is some level of bias that can creep into the tool. And if you're overly reliant on it, it can leave your organization open to claims.
Those are great, great, important points. And, I know in your experience, Aisha, that is an everyday challenge, is figuring out the balance between the company's needs and what's going to really disrupt your culture. So those are really very helpful points. And so on the next slide, a few additional comments about retention tools. These are gaining in popularity as employers are beginning to learn how much can be done regarding retention and helping employees along their career path. Several of these things I've already mentioned, but I think that succession planning is becoming increasingly popular. Using AI to assess a person's strengths within a particular discipline and area, and allowing the company to identify candidates they might otherwise not have who would be entering a pipeline for a particular line of work. Also integrates DEI considerations with regard to retaining, making sure that issues of inclusion and equity are taken into account on job satisfaction. All of that can be monitored and supported through AI as well. And then a few notes about a generative AI, the tools that create content for you. The two large buckets here are tools for applicants. You need to be aware that when applicants are using generative AI to create the content to convince you to hire them, you need to have some way of assessing, is that really reflective of their skills, or are they using AI as a crutch to create a more impressive profile? There are tools available for assessing that as well. And then as a tool for employees and management, efficiency, helping managers and employees create content, some client and customer facing content. Again, the issue is, are you relying too much on AI and some of the flaws that it has? You can lose clients and customers over this if it hasn't gone through a sufficient human review, in my view. Aisha, did you have comments on generative AI as well?
Yeah, I think it's interesting. One of the things that historically organizations struggle with is testing of applicants, right? Like, I've worked in some organizations that are like engineering based, sciences based, and they always want to have like a really neat and clean way to assess applicants, which can be challenging. But when you overlay that with the AI piece, what you have to grapple with, what are some of the ways that you can really figure out if that person is qualified. Even as lawyers, right, we used to be asked to provide a writing sample, and so how do you go about assessing whether that writing sample is actually from that individual, and do it in a way that you can assess their true qualifications for the position. And so I think part of that is perhaps making a request that they acknowledge that the sample that is being submitted is actually their original work. That may be one of the ways in the beginning of the person's journey with your organization that you ensure they really have the skills. You just don't want to come away with the impression that you've been bamboozled, that you bring somebody on board and it's like the package that they were able to generate through using AI doesn't really fully represent who they are. And then the other thing I would say on the internal side, I've gotten a lot of questions about, can managers use AI in doing performance appraisals, for example? And so my own personal opinion, I actually get to speak for myself and say, um, to tread lightly with that, not for all the scary lawyer risk reasons, but because I feel like your employees deserve the benefit of the feedback from their leader, that is really robust and is speaking to, what their performance was over the course of the measuring period, right? And so if you just put in a prompt and it's like, spit me out the performance appraisal for so and so, that completes the task, but it doesn't necessarily give the employee the feedback that they need. So those are just a couple of the watch outs from the applicant perspective of being aware that you are best positioned to evaluate an applicant who may be relying on AI, and then internally how we leverage it, again, always seeking efficiency, but not taking so many shortcuts that you deprive your employees of the experience that they really need with their managers.
Those are great
Great. Well,
comments. Thanks, Aisha. And so now we'll move into risks and the law, the developing law, and Riley is going to handle that section.
yeah, thanks, Bob. So moving into a little bit more of the nuts and bolts about the legal requirements that may not be specific to AI, but that apply in the AI kind of world that we're moving into. One of the big ones we'll talk about is discrimination law. So we'll start just with a quick overview of the different concepts within employment discrimination that are relevant in the AI workplace or when using AI tools. As we discussed, it can be used from hiring all the way through evaluation and promotion. And there are different ways that AI tools could potentially create discrimination risks. So one of those is traditional disparate treatment. This is going to be probably less prevalent in AI because disparate treatment is kind of an individualized, some type of intent to discriminate, that you're treating somebody less favorably based on a protected characteristic. If you're relying on AI and the AI is considering objective criteria, you're probably less likely to run into a disparate treatment situation. But it's not impossible because, for example, AI could be used in a way that assesses productivity, for example, but doesn't take into account somebody's disability that they've put on notice with HR. That person has a different standard or expectation. If that's not calculated into the AI, then the result of using AI could be disparate treatment of individuals with disabilities. So that's one place where that could pop up. Disparate impact is the more common concern within the AI sphere. So this is, facially neutral or otherwise neutral criteria that produce disparate results. So, for example, you have some type of input into your AI. The AI is measuring the effectiveness of candidates, and the outcome shows that, an unnaturally small amount of applicants over the age of 50 are being selected because of the criteria that the AI is considering. Even though it's neutral criteria, that outcome creates a disparate impact that could potentially be actionable. And Bob referenced some guidance out of the Trump administration yesterday on disparate impact. We'll talk a little bit more about that, but I think the important point to remember for now on any of this federal guidance related to discrimination law is that it is just guidance, and the statutes that are out there are still the binding law that will be applied by the courts. So the statements from the administration are not binding, that, private plaintiffs or courts cannot still enforce disparate impact theories. So we'll talk about a number of government agencies at the federal level that regulate employment and potentially AI tools. We'll start with the NLRB because there has been kind of marked change over the last several months in how the board is likely to police AI issues. Under the Biden administration, former General Counsel Abruzzo put out a fairly detailed memo on how the NLRB would treat the use of AI management under Section 7 of the National Labor Relations Act. So primarily that memo was focused on employee monitoring and surveillance. So for those of you who deal with the NLRA with some regularity, you'll be familiar with this, but it protects the rights of employees to engage together or work together to improve the conditions in their workplace. And when employers are monitoring that, there's a potential for a surveillance violation under the NLRA. General Counsel Abruzzo, both in her memos and in the NLRB's enforcement, suggested they would be pretty strict as far as AI surveillance tools and how they could potentially impact protected activity under Section 7. Acting General Counsel Cowan rescinded the memo that was put out under the Biden administration, essentially taking that guidance off the table with respect to the NLRB. So I think it's fair to say that the priorities of the new administration will be more focused on whether AI tools are used for what would be traditional surveillance violations under the NLRB. So, using cameras that you have to directly focus on a union meeting, focusing on productivity monitoring to see if your employees may be, stepping away from the line to engage in union discussions. Those kind of direct surveillance efforts may still be problematic, but the kind of incidental surveillance effect of some of these AI tools is probably going to be less scrutinized under the Trump administration. Good example of a case here that involved kind of emerging technologies and the interaction with Section 7, Stern Produce from the DC Circuit. This is a case where the board found a violation when a supervisor texted a truck driver who had an in-cab camera to basically say, the truck driver had covered it up during a break. The supervisor texted the driver and said, hey, as a reminder, that's against policy. You can't cover up your camera. The board found that created an impression of surveillance, that the employer was monitoring for potential protected activity by that employee through its in-cab camera program. The DC Circuit reversed in fairly stark terms, basically found that there was a legitimate reason for that in-cab camera program, and that simply reminding the employee about the employer's legitimate camera policy was not a violation of the NLRA. And they did kind of take a broadside at the board for over-enforcing surveillance in this issue, saying that the decision at the board level showed how far the NLRB had strayed from their statutory mandate. So at least a suggestion that the courts are not going to be super strict on your use of AI tools or technology for legitimate business purposes, even if they may have some incidental or theoretical impact on protected activity. Moving into the EEOC, so similar to the NLRB, when the Trump administration came in, it rescinded guidance that the Biden EEOC had issued. Again, pretty detailed guidance on how the EEOC would handle AI issues and the use of AI tools in employment decision-making. The Trump administration took that all down fairly quickly. So from an EEOC enforcement perspective, there's some unknowns as far as how the administration will try to police AI issues. That said, the statutes are the statutes and the court decisions are the court decisions, and all of these actions allow for private actions. All these statutes allow for private actions by private plaintiffs. So rescinding the EEOC guidance does not change the fact that an employee could bring a discrimination claim based on your use of an AI tool. That could be discrimination, failure to accommodate, any use of AI for retaliatory purposes. If your inputs see if the employee is a complainer somehow, and then that person is deprioritized for promotion, that kind of thing could still create a claim. And then trackings and wearable technologies, particular concern for ADA. Again, if you're monitoring speed, production, anything like that for employees who may have accommodations, the AI needs to make sure that it's aware of those issues before it assesses everyone on a completely neutral playing field. One issue that's of particular salience to this program about DEI and the administration's new priority on downplaying the role of DEI is that any AI programs that consider diversity metrics may create a target for new EEOC enforcement if they are trying to guarantee some type of diverse outcomes. So again, if your AI is trained to create, a diversity threshold, whatever it may be, you want to have a 33% diverse candidate pool, and you put applicants into that AI tool and it spits out that 33% tool, that could potentially create a problem that could subject you to enforcement from the Trump EEOC that is very focused on restricting any programs that consider diversity metrics in their decision making. Other executive orders that are relevant here, right after he came into office, President Trump put in an executive order called Removing Barriers to American Leadership in Artificial Intelligence. This is essentially a deregulation executive order to encourage innovation in AI and reduce barriers that may discourage AI developers from operating in the United States. There is some concern, as we'll talk about with some of these state laws here in a minute, that regulating AI, particularly from the developer side, so the people who are actually building the programs, if you create systems or laws that put them in jeopardy for legal liability, they may be less likely to do their innovation here. So this executive order was aimed at that issue, and notably instructed the administration to develop an artificial intelligence action plan, which is kind of a comprehensive framework around how the administration will advance AI goals by July of 2025. So as of this week, that was not out yet. But once we get that action plan, it may provide a little bit more guidance on how the administration will handle these issues. Fair to say at this point, federal policy is in flux, and there's a lot of change between the Biden administration, which seemed very focused on regulating AI and making sure it didn't result in discriminatory outcomes, versus the Trump administration, which seems a little bit more focused on encouraging AI development and dealing with the regulatory part later. All right, so moving into some of the state law issues, Colorado is kind of the leader in this area and was the first state to pass a comprehensive artificial intelligence law that includes employment issues. It's not effective yet. Its scheduled effective date is for February of next year. And it regulates, quote, high-risk artificial intelligence systems. So these are systems that are specifically designed to make decisions as opposed to just provide data. So they either make a final decision or they are a substantial factor in making a consequential decision related to both employment and several other areas. So there's consumer protections included in this law, there's credit protections, housing. All of that is kind of captured under this one broad Colorado law. But the bottom line is it has to be a decision-making tool or highly involved in the final decision, not just a piece of the data that an employer considers. It regulates both users and developers of AI technology. So generally, employers are going to be the users, and then the actual programmers or the developers are going to be the ones who are kind of behind the scenes dealing with how the tool actually works. From the user perspective, you have to disclose your intent to use the tools in advance, and also potentially provide explanations on adverse decisions that are made by the AI tool. And notably, for the Colorado law, there is no private right of action. So that's obviously a big concern for employers as far as the scope of their potential liability. If you can be sued by a private individual, that can make these laws a little bit more concerning. As of now, that is not present in the Colorado law, and it will be enforced by the Attorney General. For those of you who are familiar with the Fair Credit Reporting Act, I think there are a lot of parallels between this law and the FCRA in that it imposes obligations on both the users and kind of the programmers in the back, or the credit reporting agencies in the back. And it includes similar requirements for notice, explanations of adverse action, and imposing penalties on an instance by instance basis. So if you get this wrong in Colorado in the middle of 2026 and it applies to 1,000 employees, you could get a penalty for each instance that you use it incorrectly. So it can add up pretty significantly. So something to monitor here. California has a similar law. I won't go over too much detail here because it is basically a copycat of Colorado, except that it is broader. So it considers basically any employment-related decision as potentially problematic if it's a decision made by AI without proper safeguards. And it also includes steeper penalties, still on a per violation basis, and can be enforced through the Private Attorneys General Act. So this is not passed yet. It's possible that it won't, but there is some momentum for it in California. Unsurprisingly, for those of you who operate there, you're aware that California is often at the forefront of regulation in the employment space, and AI is likely not going to be different here. And in addition, the California Attorney General has put out some guidance on how its existing employment laws apply to the AI context. I'll go through these next couple pretty quickly. Illinois has an artificial intelligence video interview act. So if you have employees like record a video or interact with an automated tool and then you watch it back later, you may actually not even have a human participating in the interview. Illinois regulates that pretty closely, including mandatory reporting to the state about what the outcomes of that process are, as well as some kind of consumer protections on deleting the video if requested by the applicant. So worth taking a look at this one if you operate in Illinois and use that technology. And then Maryland, to Bob's point earlier on facial recognition, has put in some prohibitions on the use of facial recognition without explicit applicant consent. New York City has a pretty detailed regulation that requires basically a pre-audit before you use automated decisional tools in the AI space. So basically, if you want to use a tool in New York City before you roll it out, you kind of have to see what kind of outcomes you're going to get from it. And then in addition to that pre-audit process, it also has some of these similar notice requirements and data provision requirements that require the employer to kind of share, what outcomes it's seeing from this process. Aisha, I think you had a few thoughts on this one.
Yeah, just more generally, I think at this point, for those of you, particularly with multi-state locations within your organizations, Riley's done a great job of giving you an overview of the landscape, and your head is probably spinning, going back and forth with how do we navigate all of these things? How do we remain in compliance? How do I advise my internal clients how to stay on track? And so, one thing that really stands out that Riley mentioned is essentially Title VII, as far as I know, still the law of the land. And so despite a lot of the external communication from the current administration in the varied pockets, whether it be from the EEOC, from the DOL, et cetera, that I think those proclamations speak more to enforcement likelihood as opposed to what is the law of the land. So whenever I'm thinking about how I want to advise my internal clients, I think about buckets. What's the proper bucket for this to go into, and what am I anchoring to? In this instance, when you're talking about trying to keep up with all the legislation and the changes from administration to administration, what are some possible truisms to anchor to? And if you look at many of these proposed statutes, they anchor into a couple of areas. One is notice. Are you telling folks that you're going to be using these tools at the outset? So as you proceed with the vendor, thinking about the notice requirement, two is how are you handling their data? The Colorado statute in particular, or I don't know, it was Colorado, Illinois, that talked about deletion requirements and such. Like, how are you, whenever people want information from me internally, it's like, Who wants it? What do you intend to do with it? And how do you plan on protecting it? So those are questions that you should be asking yourself from an in-house perspective, as you navigate this stuff. And then for those of you who are blessed to have it, common sense. Just anchoring into common sense. Tools are great, but tools are not always the solution in and of itself. And even big companies like Workday are finding that out from a very painful perspective because we always grapple with the joint employer issue, co-employment issue, but they're being sued on a class basis for age discrimination, for race discrimination, and using AI tools in getting through a lot of applicants. And Workday is huge. I'm sure many of you use Workday, so there's no getting away from it. So how I try to keep my brain about me is anchoring to common sense, giving people notice about how you're using it. My only hesitation would be in the New York City instance, the kind of the bias audit. So when Riley talked about flags from an in-house perspective, we just have to be very aware of what kind of activities we might engage in that invite greater scrutiny. So if you use a word like bias audit, you may be inviting scrutiny that's not intended. But the other truisms about notice and protection, et cetera, I think should be some of the guiding principles you use as you look to leverage these tools. Thanks, Riley.
Yeah, thank you, Aisha. And those are great points. I mean, that immediately raises to me the prospect of keeping some of these internal analyses privileged too, because if you do discover bias, that could become discoverable if you don't have proper protections for those in-house reviews. New York requires you to make it public. So if you come out with bad outcomes on the audit, on the pre-audit, you probably don't want to run the program at all because you're going to have to publish those results publicly. So worth keeping in mind
and
for New York City.
I would say too, I would be remiss if I didn't do a reminder. I mean, there are in-house folks on here, but a reminder for the people that we commonly work with that we really want to work with our in-house folks or our external counsel at the outset to put something under privilege. And, our HR friends in their emails that say attorney-client privilege is not necessarily sufficient to achieve that goal. So whenever you're entering into this work, just making sure that you are making that conscious decision at the outset to protect it when you're doing, especially in this environment.
So we'll quickly run through some other state level efforts here. These have not passed yet, but just listing some of the states that have tried. Virginia did pass a Colorado-like comprehensive AI legislation. The governor vetoed it last month under the justification that he's trying to encourage AI companies to come to Virginia. So I think that's going to be the tension that you see in a lot of these laws, balancing innovation with consumer protection. You can see other states up here that have had bills that have not yet succeeded. Most states have had some type of proposal on an AI regulation that would apply to employment. So definitely something you'll need to continue to monitor at the state level. And then at the AG level, several states have put out guidance as far as how their existing employment laws apply, or privacy laws, et cetera, apply to AI issues. And New Jersey, Oregon, and Massachusetts are some of those which you can find online if you operate in those places. So quickly again on how this can practically work. On candidate selection and discrimination, AI works on the data that you give it. If you give it homogeneous data, it's going to spit out homogeneous results. So, you really need to consider, is our historic data that we're giving to this AI reflective of fair hiring? And if it's not, then we shouldn't put it into the tool. Same thing as far as diversity mandates, which we discussed before. If you give the AI, data that was created based on a threshold to have 33% diverse candidates, it's going to spit out 33% diverse candidates. And that may not be based on merit. It may be based on the inputs that were put in the tool. So that's how this can practically work. We talked about some of this earlier. So in the interest of time, I'll move on to the next slide. this is just kind of a summary to think about when you're building these tools. If you don't train your tool on complete data, you're likely not to get the outcomes that you want. And same thing if you don't, educate the tool on what outcomes you want, it's not going to know. This is kind of a checklist that you can take away for assessing your AI compliance with discrimination law. So again, kind of a summary slide that I won't spend too much time on. But if AI is making the decisions, if it's got protected characteristics factored in, that can create problems. And then obviously for all of these, it's good to critically think about what data you're asking the AI to consider and whether it actually matters for the jobs that you're hiring for or the promotions that you're making. Because particularly in the area of disparate impact, business necessity or relevance are going to be your key defense. So if you're feeding in, for example, the employee's address, which has absolutely no connection to their work performance, and the AI is somehow using that address to in its analysis, you're going to have a very tough time saying why that was a business necessity versus, some type of objective criteria that is actually required for successful accomplishment of the job. Quickly on privacy considerations, we've talked about it, but in order for AI tools to work, they need to be fed data that is usually consumer data or employee data that has some type of protection, either under federal or state law. So if you're just throwing it into this AI tool and you don't know what's happening to it afterwards, that can create privacy law liability. So consider what your state privacy laws are, work with your AI vendors to understand where the data is going after you put it in, and certainly consider any confidentiality obligations that may be implicated by putting data into an AI tool. Similar principles here, and since we are short on time, I'll keep moving through this, but these are just some questions to ask yourself when you are trying to assess whether inputting data into an AI tool may create a privacy violation. And then here are some of the tensions between the two. So this is just kind of an explanation of the issues that I'm talking about. Data protection law may say that you can only use data for a specific purpose, particularly consumer data or employee data. If you put that into an AI tool and you don't know where it's going, it could be used for an unforeseen purpose that's beyond the scope that the applicant gave it to you, and that could create problems. Individual rights, again, if a law gives the employee the right to tell you to delete their data, and you put it into an AI tool and lose control of that data, all of a sudden you may not be able to comply with that individual consumer rights legislation. Productivity monitoring state by state. Here's some examples. This has been one area where states have kind of quickly regulated on productivity monitoring. I think it's a little bit more of a big brother concern. So it is something to monitor on a state by state basis. And then common law invasion of privacy, to Aisha's point, if you are in a state that doesn't have a specific privacy law, then the employee's reasonable expectation of privacy will be considered. If you tell them you're using an AI tool, then their reasonable expectation of privacy is quickly diminished, and it can really reduce your risk there. So worth considering whether that advance notice obligation helps you both from an employment law perspective and from a privacy perspective. All right, so moving to best practices, Bob, I think I'll turn it back to you for the first one here.
Sure. We will only have the time to get through a couple of these slides and topics, but it's important to know that in your deck, we have some checklists, some practical takeaways for you about best practices. Let's actually just go to the next slide, Riley. Then I'm going to turn it back to Aisha, I think. I have some threshold questions here, which I think anybody who is considering onboarding AI needs to consider before they pull the trigger. It is increasingly frequent that someone in a company decides AI is a great idea, bringing on a product they think has a narrow application, and all of a sudden your entire operation is impacted one way or another. The first point is, are all of the stakeholders informed and on board? You got to think of everybody who plays a role in this: executives, managers, HR, unions, and of course, administration and IT. Does the company culture welcome new technology? Uh, these are sophisticated tools and complicated. You're going to need to train people. And sometimes we're seeing generational differences in the willingness to learn and adapt these. And do you have a plan to bridge that kind of skills gap, or is it going to create a dramatic disruption in your workplace? Does the vendor you're dealing with provide effective training materials and robust support? Everybody's rushing to market with these products. What they're not doing in all cases is providing robust, detailed support, manuals, troubleshooting resources, and that can create a tremendous headache for managers and HR. And then what's your goal of integrating AI? Is it cost savings? Is it efficiency? Or is it headcount reduction? Too many companies onboard AI without knowing the answer to that question. And will your company culture survive a reduction in force? Because whether or not that's the goal, somebody's going to get that idea that these increased efficiencies ought to be reducing headcount. How will you adapt to that? And does human resources have their own resources, staff, and support to administer all of this? Because all of these unpredicted headaches fall in the lap of HR, and they need to be prepared to deal with all of that. So at this point, then, I think I'm going to turn it back to Aisha, because I know she's got a series of very useful bullets and concerns and observations based on her in-house context.
So I know we're winding down, so I try to fly through this. The one thing that Bob triggered for me is you need to have an answer for your employee population when you talk about creating efficiencies. Anytime you use efficiencies, they're going to extrapolate a reduction in headcount, and you need to be able to have a really clear message around the impact to the workforce and getting ahead of it, because it'll create anxiety in the organization. And I've talked about notice, how to manage, et cetera. A couple things that I want to hit that are really, really important. Again, in-house counsel, we never want to be the stop sign. The way for us to get ahead of that is to condition our internal partners to work with us right as they're starting to consider the tool. And so forming some kind of internal group that vets from an IT perspective, HR perspective, legal perspective at the outset, and not having them come to you when they've already signed the contract. At that point, it's too late, and then you're the stop sign. The other thing is from a knowledge management perspective. A lot of times organizations, if they have budget, like to buy all the tools, and you have no idea where they are, what they do, et cetera. So making sure that there's some kind of knowledge management or tool management plan internally on these AI tools, knowing where they're kept, what they're being used for. And the last thing I'd say before you do anything is ask the vendor for references from their clients, or post implementation, or doing your own digging for post implementation experiences, because once you've signed the contract, there's nothing you can do, and then you find out all the bugs about the fact that it's not magical and it doesn't in fact do all the things that your HR team thought that it would do. It's better to try to put some wedges in on the front end to help the organization vet the particular tool that you want to leverage before you get too far. So as Bob and Riley talked about, lots of great materials in the deck. So I'll just leave it there from my perspective.
Yeah, and on the vendor issue, we skipped over a few slides, but you can go back and refer to these in the materials that were provided. To the extent you're new to this and you're working with new vendors, or you're considering new vendors, this slide here is kind of a guidepost for you to potentially use with the vendors to get an understanding of how their process works, how much control you have over your data once you give it to them, what kind of outcomes or audits they're going to review for. And generally speaking, the more willing that the vendor is to have honest conversations with you about this or give you flexibility as far as how their tool is going to work for you, the better that vendor is going to be for reducing the risk associated with the employment and privacy issues that we discussed today. So I think that brings us to the end. We're nearing time, but we do have time for a couple questions if anybody has them in the chat or otherwise.